Hey guys, I'm attorney Philip Adams with the law offices of Philip Adams in Shreveport, Louisiana, and I want to take some time to talk to you guys about a Louisiana criminal defense topic. I'm drunk and I appear in public in an intoxicated condition. Have I committed a crime? I want you to consider a hypothetical fact pattern. Say you and a friend have gone to a local bar to have a few drinks. A few hours later, after you get hammered to unwind from a long day at work, you and your friends leave the bar and proceed to walk along the sidewalk outside the bar. Now, you're undoubtedly drunk at this point, but you're not creating a scene or disturbing anybody. Many people have probably been in this type of situation at some point in their lives. However, most people probably have not experienced what happens next. Unexpectedly, after you walk about, say, 50 feet from the bar, you find yourself stopped by an overly eager police officer. Upon making contact with you, he immediately observes that you appear to be in an intoxicated condition, and then he proceeds to ask you questions. You slur your words, your eyes are red and glassy, you display some symptoms of intoxication, and within about a minute, this officer slams handcuffs on you and tells you that you're under arrest for disturbing the peace for appearing in an intoxicated condition. You're befuddled at this point, and you cooperate with the police officer, and he escorts you to his police unit to transport you to the local jail. Was your arrest by the police officer lawful under Louisiana law? Did you actually commit a crime that warranted an arrest under these fact patterns? Well, to answer the preceding question, you first have to always look at the language of the law under which you were arrested. Any crime has to be defined in legal language and contain what we refer to in the law as elements. Each of these elements has to be proved beyond a reasonable doubt by the prosecuting authority for you to be found guilty of the crime that you've been charged with. So, for example, if a crime contains elements A, B, C, and D, but the prosecuting authority fails to prove element D, then you're found not guilty because the prosecuting authority failed to prove every necessary element, including element D. It does not matter if the prosecuting authority proves beyond a reasonable doubt elements A, B, and C, if they don't also prove beyond a reasonable doubt element D. All elements of any enumerated crime have to be satisfied. In the hypothetical fact pattern that I just went over, the police officer arrested you for disturbing the peace by public intoxication. If we look up the statute for this under the Louisiana Revised Statutes, we go to 14:103A3, which reads as follows. Disturbing the peace is the doing of any of the following in such a manner as would foreseeably disturb or alarm the public. Subsection 3 says, appearing in an intoxicated condition. So as the language of the crime states, for you to be convicted of the crime of disturbing the peace by public intoxication, the prosecuting authority has to prove beyond a reasonable doubt, number one, that you in particular, number two, appeared in an intoxicated condition, number three, in a manner as would foreseeably disturb or alarm the public. So based on the hypothetical fact pattern we discussed, elements one being for identity, and number two being you appearing in an intoxicated condition, it's likely that those two elements can easily be proven beyond a reasonable doubt. There's no doubt that you're the person who was in an intoxicated condition. But can the prosecutor prove beyond a reasonable doubt element number three as required to obtain a conviction? Well, there aren't any facts in this hypothetical to indicate that you acted, quote, in a manner as would foreseeably disturb or alarm the public, end quote, which is the statutory language we're talking about, when you appeared in an intoxicated condition. So, for example, you weren't screaming and yelling while walking along the sidewalk in the presence of members of the public. You didn't curse other members of the public while you were walking. You didn't stumble onto any members of the public while you were walking. There aren't any facts in this hypothetical to indicate that you acted in a manner as would foreseeably disturb or alarm the public. Additionally, because the police officer arrested you without having any factual basis for probable cause Remember, probable cause has to be met for all of the elements of the crime that the officer is going to charge you with for the arrest to be valid. Because there aren't any facts to suggest that element 3 could even rise to the level of probable cause in this hypothetical, one could argue that this arrest would itself be unlawful, let alone talking about whether a prosecutor can obtain a conviction through proof beyond a reasonable doubt, with proof beyond a reasonable doubt, of course, being a much higher burden of proof than the burden of proof required to merely make an arrest, which is simply probable cause. Now, unfortunately, some officers might ignore the element of foreseeably disturb or alarm the public and throw handcuffs on someone simply because that person appears in an intoxicated condition. However, a competent defense attorney can look at the facts of your case in a scenario like this and determine whether every element can be satisfied in order to give you reasonable professional advice on how you should proceed in your case. So if you know somebody who gets arrested for disturbing the peace by public intoxication under Louisiana law, that person might have a valid defense to the charged crime depending on what that individual's circumstances are. Don't let a night that was meant to be relaxing turn into a charge that potentially results in a conviction because you don't know that you may have a competent defense. It's important to know your rights. Thanks.